Okay, I think we have a quorum. Good afternoon, everyone, and welcome to Trusted University. Thanks for joining us today for our webinar topic, ILITs, a strategic planning tool for large estates and a valuable consideration for smaller estates. I'm John Olson, president of LITCO. Today's session will cover the fundamentals of irrevocable life insurance trusts, why they're still relevant, how they're used to address estate liquidity and tax exposure, and how state-level estate tax regimes can make ILIT planning important even when a federal estate tax exposure is not expected. We'll also touch on the practical side, what makes ILITs work well in real life and where administration can break down. We're pleased to be joined by two attorneys from Henson Efron. First, Christopher J. Burns is a shareholder at Henson Efron. Christopher advises individuals and families on estate planning, trust and estate administration, and complex probate and trust matters, including advanced wealth transfer strategies. He is also a frequent presenter and author on trust administration and estate planning topics. Also joining us is Lloyd S. Stern of counsel at Henson Efron. Lloyd focuses on estate and charitable planning, fiduciary administration, and alternate dispute resolution, including mediation and arbitration of contested matters. Lloyd also brings a deep experience from senior trust and estate services leadership roles and overseeing complex, high-value estates and trusts. Christopher and Lloyd, thank you for being here with us today. We're excited to learn from you both. Before we begin, just a few housekeeping notes. You can use the question and answer feature to submit questions throughout this webinar. We will do our best to answer as many questions as possible in the time remaining. Also, information regarding the CE credits will be sent out after this webinar, along with a link to the recording. Please be advised, though, that you must complete the survey at the end of the presentation to receive CE credit. Lastly, you can sign up to be notified of future webinars on our TrustEd University website, which is learnwithtrusted, all one word, .com. Thank you. So with that, Christopher and Lloyd, I'll turn it over to you, and thank you for being with us today.
No, thank you.
Thank you.
And just a quick plug for the website. The website does have a lot of materials on there that are quite helpful. So after this seminar, if you wish to look at other topics and other materials, there's some very good information available on that website. So my name is Christopher Burns, and I'll be the person kind of kicking us off, but then we'll turn back and forth. And our idea is to, try to give a seminar that speaks to all of those that are attending the seminar. And as we looked at some of the attendees, we really noticed that there's some people who might be earlier in their career, might be dealing with irrevocable life insurance trusts, which we'll mostly just refer to as ILITs throughout the seminar, might be dealing with their first ILIT, might be earlier in their career than, say, people such as Lloyd and myself. And there are some of you that, are quite experienced in your field. There's also a cross-section of people in different professions that would be related to irrevocable life insurance trusts. So our goal is to have a seminar that hopefully at least speaks somewhat to the entire audience. But there might be pieces that will be too basic for some of you and some pieces that perhaps will be, too complicated for others. But our hope is that this is a resource to, build on the foundation of learning that you already have. So an overview of what we're going to do today. Our agenda is to, kind of cover some key points about irrevocable life insurance trusts. And as both Lloyd and I will mention perhaps throughout the seminar, there are some nuanced topics in our materials that literally could be a seminar in and of themselves. And it would be easy to come up with a seminar of an entire day just on irrevocable life insurance trusts. Towards the end of our materials, we're going to go through a couple of relatively simple case studies that we thought would be helpful to illustrate some points on the continued use and benefit of irrevocable life insurance trusts as an estate planning strategy, which would fit, of course, with the title to our materials. And to be clear, we see these as a strategy not just for the large estates. I heard a speaker at another seminar say, well, irrevocable life insurance trusts aren't what they used to be because the estate tax exemption is so large. And Lloyd's going to talk about state and federal estate tax exemptions here in just a minute. But we still find them to be a useful tool. One, of course, for our larger states, but two, Lloyd and I are coming to you from Minneapolis, Minnesota, and Minnesota has a relatively, it has an estate tax. And again, I'll let Lloyd speak about that here coming up next. So Lloyd, with that, I'll turn to you.
Thank you, Christopher. You gave a good introduction. I'm going to follow up with a little bit of background information, and then Christopher will then come in and give you all the in-depth of the subject. But, ILITs have been around for a long, long time. I have also been around for a long time.
I wasn't going to say that, but okay, we'll go with that.
But they're certainly not a new concept. They were very popular back in the 1960s and 1970s when the federal exemption was fairly low. Of course, now with a $15 million exemption, perhaps not as important in a lot of states that either don't have an estate tax and because of the high federal exemption. Christopher mentioned that Minnesota has an estate tax exemption of only $3 million. There are states that are a little more stingy than that. For example, Massachusetts has a $2 million exemption, Oregon a $1 million exemption, but on the upper end, New York has a $7.16 million exemption. And if you are married, multiply it by two, that increases the state exemption quite a bit. We're going to talk a little bit about the Rummy case, which dates back to 1968. And I'll let Christopher expound on that a little bit more. But, I personally feel that ILITs are still very, very an important tool in the estate planner's toolbox. This is not a political comment, but the federal exemption is now at $15 million. I would be very surprised if that continues at that high rate in the future. I haven't got a crystal ball, but I think that's a pretty good bet. I would also bet that the insurance exemption for ILITs will be around for a long time to come. So, basically, do you need an ILIT? First, you need an ILIT if you're insurable. If you're not insurable, then the subject is moot.
Well, but if you're not insurable, but you have an existing policy,
that's true.
So,
that's another subject. But even being insurable today has changed because life expectancies have changed, and someone that may have not been insurable 20 years ago may be insurable now. Also, in addition to being insurable or having an existing policy, you have to have a need for liquidity. And there are many cases where you will, and Christopher will expound on that, but certainly if you're heavily invested in real estate, if you have a closely held business, or if you have a lot of your estate assets in an IRA account, you're going to need some liquidity at the time of death. So, Christopher, I know you're going to expound on all this, but I still think that ILITs can be a very useful tool, especially in states with smaller exemptions such as Minnesota, but also we have a large high net worth individual that exceeds the $15 million exemption, because don't forget, after $15 million, there's still an estate tax of 40% on the remaining amount. So that can add up pretty quickly. So,
and we'll get to that in some of our examples.
Perfect.
The point that didn't get made, that got skipped here was, for a good summary of the state estate tax, for each of the states that we might have here. Again, we didn't want to do a detailed explanation of all of the state tax exemptions. We suggest Googling or otherwise using whatever search engine you like, ACTEC state estate tax exemptions, and that will bring you relatively quickly to a good summary of every state's state estate tax. And so I just wanted to leave on this screen just for that mention that was omitted either by Lloyd or myself. So as Lloyd said, irrevocable life insurance trusts do provide flexibility. And as he also said, the only certainty in government seems to be that tax laws will in fact change in the future, whether they'll be repealed, whether the estate tax will continue where it's at, which current legislation has that doing, or whether the exemption will change over time. And again, these aren't intended to be political statements by us, but rather just practical statements. On this slide, I referred to an ILIT as being the holy grail of transfer tax planning. And I wanted to call out that a portion of these slide materials were developed previously by me with another author, an attorney in Minneapolis by the name of Jim Lamb with the Lathrop Law Firm. So I wanted to give Jim a shout out at this time. And he's used these materials in independent seminars he's given, and now I'm using them in my chat with you. And some of these are derived, of course, from materials that Lloyd did back when, Lloyd, you first lectured on this topic, you guessed, in about the 1980s.
1980s, I would say. Yeah.
So probably before a couple of the people in the audience were around, much like the Crummy case was before my time, but we're not going to go there too much further. But just know that, we want to talk about leveraging the benefits of gift tax, annual exclusions, and to get death benefits to family members and other beneficiaries. We won't in this talk be talking a great deal about charitable beneficiaries, but talking about human beneficiaries. So here is just a summary of some of the advantages that we perceive of ILITs. The exclusion from the estate, and that's what Lloyd was referring to in his introductory comments. One of the nice benefits if they're excluded, and this was what Lloyd was referring to, is if you have illiquid assets in the estate or assets you don't want to be sold, but for various reasons need to be in your estate at the time of your death, the liquidity from the life insurance could be used to purchase the assets from the estate of the decedent at fair market value to provide liquidity to pay tax if, in fact, an estate tax is due. And so, it's a significant benefit. This also works in conjunction with IRA benefits and things like that so that you have the liquidity. We don't want to create a situation where you have to pull money out of an IRA, pay income tax on that to turn around and pay estate tax. It gets to be a real circular calculation. And in our experience, one which no matter how you calculate the taxes using the IRS guidance, or for us, the state of Minnesota guidance, the taxing authorities seem to disagree with the calculation that you come up with, even if you use the same calculation you used the last time with them. Other advantages are listed here, but I really think of an ILIT as part of a comprehensive estate plan that really allows you to do a lot of things. Now, for many clients, it's the block and tackle, getting the healthcare directives, the powers of attorney, the beneficiary designations, and the will and the trust in place. Sometimes the ILIT is seen as building on that foundation and growing on that. And sometimes that leads to other tools like spousal lifetime access trusts and GRATs and all of the other tools and acronyms that we can come up with. But these are really one of those foundational documents that come immediately after that base foundation, at least in our opinion. Some of the disadvantages of ILITs, just to understand them, it is irrevocable. And we have had some clients, really look at that and say, I just can't get my hands around irrevocable. And for that reason, some clients choose not to wish to use this tool. Again, it is a fantastic tool, but if they have reservations in that regard, that's important. Also, the transfer of the policy to the ILIT is irrevocable. Now, some ILITs would, have perhaps some swap type provisions, things like that, but we encourage clients not to use irrevocable life insurance trusts with any designs to ever get the insurance out of the trust. Now, we're going to talk a little bit about income and principal distributions and how that might work. So that might be an exception to that. But, also sometimes settlers, think, well, wait a second, I want to use this policy and I want to make loans from it so I can have cash or things like that. Again, the transfers are irrevocable. You lose the ownership benefits. And there's also a 3-year rule that we're going to spend some time talking about in a few minutes. So there are some disadvantages and things to be explored with your clients when you talk to them. But again, in our assessment, in our opinion, ILITs are often a fantastic tool.
I wanted to just mention something. This is really a long-term commitment. So somebody that's looking at establishing an ILIT, you got to realize you're going to be contributing for a number of years, maybe 20, 30 years, depending on the lifespan. So this is not something you get in and out of real quickly.
For those of you in the audience that are drafting documents, here's just a couple of considerations to think about. Again, Lloyd and I are licensed to practice in the state of Minnesota, so we're not trying to cross boundaries and things like that, but just generally applicable considerations. The estate tax exclusion depends on the the trust being irrevocable. And different states have different rules about whether a trust, just by being drafted, if it doesn't say otherwise, is irrevocable or not. And as we looked across guidance provided by practitioners and lecturers in a number of states, and materials written by others for the American Bar Association, it seems uniform that lawyers tend to recognize and recommend that you make it crystal clear that the trust is irrevocable so that you don't have inclusion issues under 2036 or 2038 of the Internal Revenue Code. All of the references in these materials to IRC is referring to Internal Revenue Code. We should also state that the trust, the settlor, and by the way, I want to call this out to be clear as well. The settlor is a term of art used in Minnesota for a person who creates a trust. I know other states refer to that person as trustor, grantor, trust maker, what have you. Again, in Minnesota, the term is settlor, so that's the term that we'll use. We, in one slide later, refer to grantor. We're referring to grantor trust tax powers. And so hopefully that will be clear. But the settlor, being the person that creates the trust, the document should be very clear that they're giving up incidents of ownership and that the trust and any transfers to it are irrevocable. Now, the selection of the trustee is likewise an important consideration, and oftentimes people, try to work with complex things with people that aren't capable or otherwise amenable to taking care of these sorts of issues. And the selection of the trustee can be critically important. A business owner that wants to select their partner to handle this, that business owner, when the first business owner dies, that person might be overwhelmed with all the work that he or she needs to do to keep the business up. Naming them in all sorts of fiduciary responsibilities could create conflicts for them between their different roles, duties to the business, duties to beneficiaries, things of that nature. Lloyd, you often like to talk about the importance of selecting the right trustees, such as our sponsor for things like this or others.
I just wanted to mention, years gone by, a lot of the larger banking institutions would take on being a trustee of an ILIT, but they would take that on somewhat reluctantly. They would usually do it where the individual was a good client of the bank, and they would do that as a favor. In the old days, they would charge maybe $500 a year. That fee went up to $2,500, $3,000. And now a lot of the larger banks don't want to be in the business because of the liability involved and the small fees, relatively small fees involved. So while it's a good idea to have a corporate trustee, you may have to shop around a little bit to get a good corporate trustee.
And it used to be the belief for some that you would buy the life insurance policy and never look at it again. And, markets and assumptions have been different. And there have been some insurance companies that are no longer with us. And so, having some ability to have some review and due diligence on things can also be an important characteristic. We typically recommend, and again, I think this is a generally applicable recommendation, but specific also to Minnesota, to be very clear that the settlor, the person creating the trust, cannot serve as trustee. If they do serve in that capacity, then that can be an incident of ownership. Another caution here is, and we'll talk about different types of policies a little bit later in the seminar, but if the policy owns a second to die life insurance policy, or if the ILIT might ever have a second to die life insurance policy, then the person's spouse, if that's the second to die person, should not be a trustee of the ILIT either. So again, a lot of traps for the unwary, and we're trying to help you navigate through the minefield that is this type of planning to avoid some of those traps. Now, we talked earlier about the 3-year rule, and we said we'd come back to that, and now is that time. If the ILIT is funded with an existing policy, so in Lloyd's earlier statement when he said, the person has to be insurable, and I chimed in with a caveat, unless they have an existing policy, this is kind of what we're referring to. If you transfer an existing policy into a new irrevocable life insurance trust, now there's some minor workarounds on this, but in general, the transferred policy is going to be included in the settlor's estate for estate tax purposes for a 3-year rule. This rule was designed to prevent deathbed transfers of policies to get them out of the estate and to avoid the estate tax. In our office, to mitigate against this, should the person die within that 3-year period, we often will use a marital trust in the estate planning documents and then can make the choice to Q-tip or not Q-tip those as the case may be. Now, for those of you in the audience that are getting a little bit lost, again, here is where we're trying to speak to the very experienced people in the audience, as well as to those that have less sophistication. A qualified terminable interest property is a lecture in and of itself, but just know that this is important. For those of you that are in Minnesota, know that the 3-year rule has been adopted by our taxing authorities for any irrevocable transfers. Elsewhere, it generally applies to the transfer of life insurance policies within 3 years of death. Again, not going to do a detailed exposition on Minnesota, but did recognize a few of the attendees' names from being from Minnesota here. So mention that. Earlier, we also mentioned that, generally once you transfer a policy in, you're not going to be able to transfer it out. And I mentioned that the income and principal provisions may give some opportunities for some planning. We have had an instance where a person created an irrevocable life insurance trust. They funded it with a policy, and they decided they didn't want the management anymore. The policy was paid up and what have you. And they used the income and principal distribution power in conjunction with the trustee to distribute the policy to their child, to have the child continue to own that. Now, that's uncommon. I can think of on one hand, and by the way, one finger, how many times I've done that in 27 years of doing this. So relatively rare, but sometimes we fund irrevocable life insurance trusts with assets in addition to life insurance, such as transfers of cash or transfers of marketable securities and things like that. So know that, income and principal distribution provisions are important. Now, we're going to be talking a great deal about crummy withdrawal rights here in a minute. And so we'll get more in depth on that, but know that transfers are subject, whatever the transfer is, generally speaking, to a crummy withdrawal right, unless that's suspended in some meaningful way. So in our irrevocable life insurance trust drafting, we make it very clear that we want the proceeds, the amounts gifted, to be used to make sure that the insurance premiums are tended to by the settlor. We often have the settlor open or establish a bank account for the irrevocable life insurance trust and work to direct that the premium payments are timely made so that crummy notices can be sent out, what have you. We'll talk a bit about timing for crummy notices in a few minutes. Now, I want to talk here briefly just about second to die life insurance policies. Again, we often use these to pay the estate tax. As Lloyd mentioned, often we can avoid the payment of an estate tax on the first death. We can have provisions to leave assets to the surviving spouse, take advantage of the marital deduction, whether it's through a marital trust or outright distribution to the surviving spouse. Often we use the second to die policy then to pay the estate taxes that might be due on the death of the second of the two people in a married couple. Have to think about this, be careful with this. These types of ILITs often differ from other types of ILITs in that you don't want the spouse to be a trustee to avoid those pitfalls that we talked about with respect to 2042 of the Internal Revenue Code. Want to be careful with the spouse being a beneficiary for other estate inclusion problems, for income principal distributions. Careful consideration to having second to die in single death policies in the same ILIT. We've done that from time to time, but we tend to generally avoid it. Now, to be clear, there's no reason why we can't have multiple irrevocable life insurance trusts. And sometimes needs change, desires change, planning ideas change over time. So take that into consideration as you work through these issues, but know that you don't have an annual tax exclusion for each ILIT. You have it for, specific individuals. You don't have it for each irrevocable life insurance trust. Also know that you have to take into consideration, all of the different gift tax considerations as they relate to planning. And if the settlor makes a gift, if we want that to be considered what's called a present interest gift, and that's where we get into wanting to talk about, the crummy power. Now, the crummy power isn't a crummy thing because it's a bad thing to do. As Lloyd said, it dates back to a court case from 1968 in which a dentist had a trust that he created that was irrevocable. And the IRS looked at it and, inferred that, beneficiaries had to have a present interest in order for those gifts to qualify. And present interest, means an unrestricted right to immediate use, possession, or enjoyment of the property. And we've cited the Treasury regulation under the Internal Revenue Code for that proposition. Now, it is interesting also to note that this dentist, Dr. Crummy, didn't realize that he was somewhat famous in our area of the law. And there was a person on the street interview with him, in the early 2000s, I believe it might have been the late 1990s, in which, this person had no idea that people were using his name all the time to talk about this estate planning strategy. So every ILIT, every irrevocable life insurance trust that I've ever worked on has been some form of a crummy trust. Now, there are crummy trusts that are not ILITs. Again, those might be a crummy trust that solely receives gifts of income or stocks or bonds or other assets gifted to it, real estate, what have you. But every ILIT in general that I can think of has been a crummy trust of some sort or another. Now, the amounts that many of your clients will cite back to you is the $10,000 exclusion that was the historical amount. That has changed over time. And again, the annual gift tax exclusion for last year and for this year is $19,000.
I just want to mention perhaps at this time that it's a good idea to talk to the ultimate beneficiaries of the trust at the time you're making the ILIT so they understand what you're doing and what the overall intent is. It may avoid some tough decisions as time goes on.
So I think what Lloyd is referring to is what some practitioners call the woodshed conversation, so that the kids know that the purpose of the crummy notice, the crummy trust, is to buy life insurance, which will later benefit the crummy notice recipients, so that they understand that they probably should leave the gift alone and let it remain in the trust. Now, whenever we send out crummy notices, we like to have the individuals initial something that just simply says that they received their crummy notice. We also like to have them or have the settlor keep copies of any notices that he or she sends, or excuse me, the trustee keep copies of any notices that he or she sends. Now, we don't want the crummy notice recipients to acknowledge that they're, releasing a crummy withdrawal right, what have you, because we don't want to cause inclusion issues under 2514B. Rather, we're just having them acknowledge that they received the notice letter. Now, Lloyd and I have both had clients that have been subject to audits over the years. And, I've got two audit related anecdotes to share just to give this some perspective. Because some of you might be wondering, is all of this really necessary? Does it matter? These notices, what have you, the IRS isn't going to care, the so forth and so on. Well, the answer is when you get audited, the IRS does care. Minnesota Department of Revenue, for those of you in Minnesota, does care. And so we had an audit a while back in which when the auditor asked, well, have you given crummy notices? Can we get all of the copies of your notice letters? My client in that instance did not have copies of all of the notice letters, but they did have a spreadsheet where their kids had initialed each year that they had received notices, and that was fantastic. Now, I had a second audit experience when the same issue came up, and I believe any sort of statute of limitations has long since run, where I noticed that the color ink used for every set of initials was the same. And so on that one, I scratched my head a little bit and said, did they really initial every year annually when they got it, or was this done, after the fact? Albeit they did acknowledge that they had received all of the notices and were aware that they had the withdrawal right. So perhaps maybe that's sufficient. Here again is the citation for the crummy case that we've been talking about. If you wish to read it, And again, back then the exemption was much less than what it is now. And it's an interesting read of a case. Suggest that if you're so inclined. As I often tell my wife, she's happy to read any of my materials if she needs a sleep aid in the evening. And she's never made it through one of the cases I've suggested that she choose to read. The next thing we want to talk about just a little bit is kind of notice time periods. Donee has to have, an opportunity to exercise. You can't say that you've got to exercise it by tomorrow, what have you. So our standard practice in our office has generally been a time period of about 30 days. Have we ever done less than that? We have when a client has asked us to, but that's a comfort level that we have. Again, a donee must have current notice of any gift. So, we'll often write an initial crummy notice letter that says this might be the only notice that you'll receive, but we really feel more comfortable with doing annual notices every time a gift is made, just so that we don't have these sorts of issues. Arguments have been made by some pundits that it's the actual notice that matters, not the letter per se. So maybe, if the person acknowledged that they knew that mom or dad made a premium payment, what have you, or made a gift to the trust, maybe that would be sufficient. Again, we're trying to recommend taking the careful and cautious course as opposed to unnecessarily taking risks that, aren't necessary under the circumstances. Again, here we talked about reasonable period of time, and we cite at least we cite a revenue ruling here that determined that 3 days to withdraw was too restrictive, wasn't enough time. Again, we always feel that our clients do best when they don't have cases named after them or revenue rulings that are unsatisfactory. So again, knowing Lloyd and I being cautious people. You can ignore the reference at the end of this paragraph. I had attempted to strike that previously, and it didn't seem like that strike held. But the trust may be drafted so that the trust doesn't need to retain cash to survive the withdrawal rights. Maybe other things could be distributed as part of the crummy withdrawal power. So think about that. Technically, you could have a fractional interest in a life insurance policy is what they could exercise, or other assets in the trust that could be satisfied. That's why sometimes we do have some cash in the account in excess of the amount of the insurance premium so that something could be withdrawn easily and not cause a hardship. Now, we talked earlier about we have an understanding that woodshed conversations happen. Again, no coercion can be done, no physical threats or other threats. Now, I had the privilege with Mr. Lamb that I mentioned before of speaking to an audience of about 700 people at a conference here in Minnesota. And I asked the question at that conference of the 700 attendees, how many people have had someone exercise a crummy withdrawal power? And these were experienced practitioners for the most part. And we had 2 people raise their hand. Now, they came up after the seminar and we asked them, did those crummy withdrawal beneficiaries, notice recipients, ever exercise that crummy withdrawal part, a second time? And uniformly, these 2 senior estate planning attorneys said no. So once, to Lloyd's point, they understand the benefit of what this is all about. Typically, they won't exercise that. Again, you can't impede that power, and education on this is terribly important. And again, we cite some cases to avoid some sort of prearrangement with respect to the present interest, what have you. Another issue that a great deal of time could be spent on is just to talk about a prearrangement with respect to this situation. And to go from prearrangement, the next thing is the Cristofani case. And the Cristofani case, was one, and again, it's worth reading as is the Kolstad case, where you can't have, you can't list, all people in Minneapolis as crummy withdrawal power holders and publish a notice in a legal newspaper or something like that. They want beneficiaries that have a legitimate interest, to be able to demand distributions. And so take a look at that. Sometimes with large premiums, you want to, try to expand the class of people that could receive crummy notices. And, it's an area where we could see someone tripping up relatively easily. More in the Crummy case and the Cristofani case and what have you. Again, what the service is looking at is a system, to avoid flagrant abuse by excessive Crummy notice beneficiaries. They want it to be a bona fide gift. And there's a technical advice memorandum there as well. Legitimate donors are fine, or legitimate recipients are fine, people that might receive notice. Again, if it's a spousal situation, you can have $19,000 from each spouse. To be clear, you can't have other gifts to the person as well. Now, some people choose to utilize or use some of their annual gift tax exclusion as they fund these policies as well, fund the, irrevocable life insurance trust as well. And know that that's an option. Now, sometimes we have used what I would call hanging powers as a part of this. Now, a detailed exposition on hanging powers is beyond the scope of what we're going to do today, but maybe you're giving a notice, your notice time period when you're doing the premium is, late in a year, and you have some power hanging over into a subsequent year. Sometimes, that situation arises. We try to avoid that. But a hanging power allows the rights of withdrawal over successive annual contributions, to kind of hang around and to accumulate until they can gradually lapse or disappear. So if the withdrawal power, if maybe the policy is weighted such that the premiums are greater early on and lesser at a later point in time, these are things that you might wish to think about as you draft. Now, these aren't kind of the basic 101 drafting of your first ILIT, but something to think about. Now, a disadvantage of a hanging power might be that the power holder might exercise these crummy powers at a later date. The amount that hasn't lapsed, well, that could be in the power holder's estate at the time of his or her death. Many people have looked at some of the private letter rulings on this subject and not felt terribly comfortable with what the IRS might do with respect to this in a detailed audit. Also, something we're not going to have time to address today is planning with a split dollar arrangement. Note that split dollar arrangements can work particularly well for closely held and other people associated with a business. A split dollar arrangement is between a policy owner and a non-owner to pay some or all of a portion of a policy premium payments, and there's a regime with the either a loan regime or an economic benefit regime. And this topic in and of itself is another thing that could be an entire seminar. So just mention that for your knowledge and consideration that there are some tools, and stay tuned for future seminars on some of these more complex topics. Oftentimes also there's loans and premium financing that can be done to pay for premiums, whether subject to split dollar or otherwise. Again, here we're just mentioning this for completeness for all of you. Initial funding of a trust is also something that is important to think about. Ideally, in the ideal situation, best case scenario, again, to Lloyd's earlier point, if the person is healthy and insurable and so forth, is for the irrevocable life insurance trust trustee to be the applicant for the policy. Get the new policy, no 3-year rule, and administer the policy accordingly. Now, sometimes agents, can do substituted policies and things of that nature, but know that that ideal situation in our mind seems to be that. Make sure that the settlor insured, think about this. If you're doing an existing policy, make sure that the settlor insured is the owner of the policy. Can't be transferring policies owned by others. You don't want loans to exceed basis, so you really need to understand the nuts and bolts of the policy if you're going to use an existing policy. And you really need to think about all of these sorts of issues as far as the assignment of the policy. Now, we want to talk a little bit about some of the trustees' duties after the initial funding. And if you're working with our sponsor or other sophisticated outfits in administering the irrevocable life insurance trust, they'll know what their duties are. They'll know that they have the duty to give these trustee notices, but they also know that they have to be prepared to administer this as a trust and all of the fiduciary duties that can apply to administering a trust. They need to track the crummy powers. They need to pay attention to the crummy powers. They may need to file income tax returns for the ILIT if it's necessary, if there's other investments in there. And they need to invest the assets other than the insurance policies. And they may need to periodically examine the insurance policy itself, as we discussed earlier. Some states and some practitioners suggest some sort of annual account, to the extent the account statement isn't sufficient. Again, working with a trustee such as our sponsors, you'll get that information. You won't necessarily get that if you name an individual. So
it might be possible to have an individual as a co-trustee with a corporate trustee, but that's neither here nor there.
no, certainly something to think about, and often something to consider with respect to trusts. Might make people more comfortable with an irrevocable type of document. The trustee duties after the settlor's death, this isn't intended to be a comprehensive list, but wanted to kind of draw your attention that there's some work to be done. Investments need to be made. We might need to take care of some of these liquidity provisions. The irrevocable life insurance trust trustee needs to be in communication with those who are administering the decedent's estate, whether it's a personal representative or a trustee. And so there's some synergy that needs to take place. We had a situation in our office not too long ago where parents divided the different fiduciary roles amongst their kids, and their kids didn't get along well. That would have been a nightmare had that decedent had an irrevocable life insurance trust, having kids that won't speak to one another try to administer two different types of trusts. So just know that that's something to be mindful of. We've also had to work with the irrevocable life insurance trust trustee to participate in audits of estate and gift tax returns when the decedent died, and again gave an example of that a little bit earlier. Now, we want to talk a little bit in the time that we have left just about different types of life insurance that can be used in ILITs. And Lloyd, you and I talked about this previously as to types of policies that you like to use or have clients use for life insurance trusts. Do you want to share a little bit more about that?
Yeah, I would say pretty much do not use term policies if at all possible, but also policies that do have some equity, like the universal life and variable life.
And I would put a caveat on the term. Sometimes people with young children will use a term policy in an ILIT just to make sure that their kids get some money should they die at a young age and their surviving spouse choose to remarry. But generally speaking, we focus on the more permanent types of life insurance policies. I've done irrevocable life insurance trusts with term, whole life, universal life, variable life, second to die, and even group insurance. Now, I have not personally done those with a long-term care policy with a death benefit, but do know that others have navigated through those hoops and done so successfully. I just personally haven't had the opportunity to do just that.
I recently had a case with a term policy, which was not in an ILIT, but the insured individual, as she got older and older and older, of course, the premiums kept going up and up and up. And eventually she reached 80 years old and she couldn't afford the premiums anymore. So.
Yeah, that happens. We've talked a great deal about crummies. We've tried to talk about crummy notices from an estate tax perspective, from a gift tax perspective, from a notice perspective, trying to cover it from every angle in our materials. And again, this goes again to timing and notice, what have you. And again, the benefit of explaining. One of the things that we see, and one of the reasons we emphasize this, is so often people want to do an estate plan and not talk to their kids, not talk to their loved ones about it. And this is one of those instances where having that open, candid conversation proves inordinately helpful and makes for a much easier administration when the person is gone, or when mom and dad are gone, as the case may be. Now, I mentioned earlier, and this slide calls it out, the trustee to satisfy a crummy withdrawal right. Might be cash, might be the current amount that was gifted to the trust for that particular crummy beneficiary. It could be a portion of the ILITs life insurance policy. You could do some sort of division. I've never done that, but I'm aware of others who report that they have. I'm not saying I disbelieve them when I say they report that they have, but I personally haven't seen evidence of that. But the policy, or excuse me, the trust agreement could certainly call for that, and we could satisfy it perhaps in other ways, maybe a loan against the policy to satisfy the crummy withdrawal rate of a beneficiary. All of this is about, or much of this is about property management, but it's also about that estate tax avoidance, trying to mitigate the estate tax. Now, I say not all of it, because there's some asset protection planning that can be done that might not be entirely estate tax related. We've had many clients, disproportionately doctors and people like that might have some fear of future lawsuits and things like that. Now, I'm not going to get into a great deal of detail about asset protection strategies and some of the great things you can do in the state of South Dakota and otherwise. That's again a bit beyond the scope of what we're here to talk about today. But just know that that's yet another benefit of this, in addition to the estate tax planning. We're kind of focused on the gift tax and estate tax benefits that are associated with this, or the smart utilization of gift tax planning to take advantage of the estate tax mitigation. But know that there are other benefits as well. Again, we're trying to make sure that the person doesn't have the economic benefits of the policy, so that the policy is not included in the person's estate. Incidence of ownership is the term that's used. And here's a summary of some of the cases and some of the things that look at whether or not someone has incidence of ownership in a life insurance policy. And again, some of these cases go back even before Lloyd's time, 1939. So we try to.
Yeah, thank you very much.
You're welcome. You're welcome. So many of the other cases, though, being much more recent. Just to understand, we're trying to make it so the person doesn't have that incidence in ownership in a policy if they have it into the irrevocable life insurance trust. Now, I feel that we've covered ownership within 3 years of death enough. We've beaten that horse, as it were. I want to just make passing mention to a couple of other concepts, and we'll get to our examples. For those of you that do spousal lifetime access trust or limited access trust as part of your estate plan, know that the reciprocal trust doctrine is important. A husband and wife shouldn't do exact mirror image life insurance trusts, sign them on the same day, leaving them in the same economic position as they would have been before. Certain things to think about. Again, the reciprocal trust doctrine is something that if you have a situation in which trusts are being done contemporaneously, and I'm speaking here of irrevocable trust, not revocable trust, irrevocable trust being done at or around the same time, to be mindful of that. There's a lot of good materials in this area with respect to SLATs, again, spousal lifetime access trust or spousal limited access trusts. Again, different people seem to call them different things. Just a mention of a case in Minnesota, make sure that when you draft these trusts, you make it clear that if the only asset's going to be life insurance, that the trustee doesn't have a duty to diversify. There was the Williams case in Minnesota, the Dumont case in New York, some cases in Tennessee and elsewhere, and a good summary of some of the diversification duties in Ohio Law Review. That's Jeffrey Cooper's Law Review article, which is a good read that may or may not put your spouse to sleep, as I referenced earlier. So I want to get to the case studies in the remaining time that we have left, and to talk about that, to hopefully cement for all of you, what some of the important provisions that we've been talking about, in fact, are. So the facts of the case studies are not listed here or any of our slides, but rather we're going to just kind of talk through them. So case study number one, Lloyd, is a single individual, and we're using single individual so that we don't need to get into the DSUI amounts, the portability issues, what have you. So all of our examples are single individuals, just to know that married individuals have perhaps DSUI and other issues, deceased spouse, unused exemption amount issues. So here we have a $30 million client. They're single. They live, at least initially, this person lives in a state that doesn't have a state estate tax. So they're in the state that does not have a state estate tax, but this person is adamant that they want $30 million to go to their beneficiaries, their desired beneficiaries. Now, early on in our materials, I said we're not going to be speaking about charitable beneficiaries, but Lloyd and I both love to do charitable planning for clients, so we're not saying that's a bad thing. We're just not focused on that today. All of this person's beneficiaries are individuals. None are charities. And their assets for case study number one consists of stocks and bonds and cash. This person's young, they're healthy, they're insurable. They don't have real estate, they don't have farms, they don't have closely held assets. You might think, well, why would this person ever need a life insurance trust? Why would they ever need to do any life insurance planning? Well, we had a person that very nearly fit all of these definitions. They did have a home, but they otherwise fit all of these definitions. And when we talked to them, the insurance for them was so affordable. And this person had some actuary background, financial background, that when we ran the numbers and they ran the numbers and they worked with their financial advisor team, he had a couple of different individuals that he worked with, it really seemed to him to be a no-brainer. Again, he wanted to make sure that under any circumstances and under market volatility and other things that he could get $30 million to his desired beneficiaries, nieces, nephews, people like that. And so, we worked with him to acquire life insurance so that he could meet this situation. Now, without the benefit of the irrevocable life insurance trust, which he paid for from income from his investments, just to put some numbers on it, again, $30 million net worth in a state that doesn't have a state estate tax. Using Number Cruncher, we just, did the simple calculation of what his estate tax would be, and we calculated that his estate tax would be $6 million. $6 million of estate tax. So his beneficiaries would get 24 million. So his challenge to us was to find a way for him to, make up that $6 million in estate tax. And again, with his insurability, we were able to facilitate that with his other advisors, with an irrevocable life insurance trust. Now, staying on case study number one, Lloyd, for a minute, you talked earlier about retirement account assets, not needing to deplete those.
Very common today.
And so that could certainly be a thing. We certainly, with some of the doctors and other professionals that we have in our office that we get the privilege of representing, they often have very large retirement accounts, deferred compensation, things like that. Not having to liquidate those accounts, but have those go to beneficiaries or back to charitable planning, maybe to some charities if the person's so inclined. Closely held businesses is another sub case study under case study number one. Now, with closely held business owners, it sometimes gets even more complicated because if they have other business partners, you need to understand the buy-sell agreement or other corporate documents. Now, Lloyd and I have the privilege of just being able to walk down the hall and talk to folks in our business group about these other documents, and often a close partnership with them and coming up with a plan that fits all of these different parameters. Often we see these buy-sell agreements for clients, and when we first start talking to them about life insurance, they say, oh yeah, I was supposed to do that back when we did this buy-sell agreement, but we never did buy the life insurance. And we scratch our heads and we say, okay, that was designed for a purpose. You might have to buy out your business partner at a time that the business is in crisis and there's no insurance to assist you with that downstroke or otherwise handle that. Likewise, we've had issues for clients with closely held real estate holdings. We had a client that had a lot of land around one of the suburbs here in the Twin Cities, and they had no liquidity to pay the estate tax. It wasn't necessarily a good time to be selling land at that time, or at least not in that area. Thankfully that person was insurable. We were able to get an irrevocable life insurance trust in place for them. And in Minnesota, we deal with these, and as they do in the Dakotas and, all throughout the Midwest and, well, really throughout the entire United States, with our farm clients, farm owning clients. particularly farm clients that, have suburbs and exurbs kind of approaching that where maybe their land values are going to spike. And so irrevocable life insurance trust can be a great example in that case. Now, all of those different case studies, we also need to think a little bit about how those apply for people that do live in states with state estate taxes. So take the same $30 million client and say they chose to move to the great state of Minnesota. Lloyd's a transplant to Minnesota from elsewhere. We often joke that when people marry to a Minnesotan, they end up getting stuck in Minnesota. It's kind of like Hotel California. Once you come here, you can never leave.
I might say I grew up in Rhode Island and Massachusetts, and those two states are even stingier than Minnesota as far as state tax.
Well, and you even spent some time in Florida, yet you still came to Minnesota.
Yes, well, that was a mistake, but
Yeah.
we won't go there.
All right, we'll leave that well enough alone. So same person, $30 million estate, just to give some of you who are elsewhere across the country some perspective. Remember before we talked about $30 million person living in a state that doesn't have an estate tax. In Minnesota, that same $30 million person who would have paid a $6 million estate tax is paying almost a $9 million estate tax by dying a resident of Minnesota. And we literally do call jokingly Minnesota Hotel California from time to time because it's easy to come here, but it's hard to leave. And that's not just because your car won't start or isn't stuck in a snowbank, as the drum roll goes. Now, we also talked about that in our opening comments that it might not just be for these very large federally taxable estates where this matters. It might also be for clients with lesser amounts of an estate. And we've used irrevocable life insurance trust successfully administered by, good trustee for estates of $6 million. Now you might say, well, why $6 million? That's far less than the $15 million exemption, Christopher, that you spoke of earlier. Well, we've used them in those cases because of the Minnesota state estate tax. And for the 15 states plus the District of Columbia that have an estate tax, certainly a consideration. Again, an irrevocable life insurance trust might be a consideration for asset protection, for other planning purposes, not just the estate tax. So I want to make sure that that's clear. But, in a situation that we had with a client that had a $6 million estate, single individual wanted it to go to certain beneficiaries, wanted that amount to go to certain non-charitable beneficiaries. We had a $390,000 state estate tax to plan for. Again, this person was insurable. We were able to do it with new insurance. In case study number 2, I'd be remiss of saying that, in that instance, we actually did 2 irrevocable life insurance trusts. We did one for an existing policy, and we did a separate one for a new policy. At one point, they weren't sure if they were going to keep the existing, but we, worked to deal with that situation as it was. So we've tried to cover in the 58 minutes that we've been speaking a great deal of materials. And, there's more that could be done, if we had more time. We appreciate all of you that have joined us here today. And as we haven't allowed a good deal of time here for questions, our contact information is in the materials. We welcome the opportunity to have people email us questions. John, did you have any other items that you wanted to talk about as we closed up here our time today?
Well, we did have 4 questions come in, and if you don't mind going over for a few minutes, I thought they were good questions, and we'll try and keep just maybe address these briefly. So if we can, I'll just read them to you, and anyone who's willing to stay on, we'll address them, and they have your contact information for any reattacks after that. But does that work for both of you, gentlemen?
John, and if the questions require us to get more information, we'll just say we might need more information on that and then have the person contact us directly. But let's jump into the 4 questions, and if we don't need more information, we'll do our best to answer them.
Perfect. All right. The first one is, can a settler have a quarterly review of the performance of the invested premiums and still avoid incidents of ownership?
So I'll just repeat the question. Can the settlor get periodic reviews? I think the questioner asked about quarterly and avoid incidents of ownership. getting updates, we've not seen any cases or other law that says that the person continuing to get updates on the insurance performance would cause issues with respect to inclusion of the policy in the estate. So specifically, for people residing in the state of Minnesota, we've not seen that, nor have we seen any published federal cases that say that the person being kept abreast of information with respect to the life insurance policy would cause incidences of inclusion. The settler might, in fact, if the policy isn't performing well, choose to not make future gifts to the ILIT on a going forward basis and let the policy lapse in some instances. And we have had policies lapse inside of an ILIT when the person hasn't chosen to make continuing distributions, albeit we've tried to brainstorm with our clients on that particular issue. Lloyd, any supplemental thoughts?
Well, some people may not want to do it on a quarterly basis. It's certainly a good idea, and it's really a necessary idea if you're a fiduciary to continually review the policies. So
on an annual or so basis.
Yeah.
Okay.
And that's distinguished from exercising investment discretion over the ILIT. If they don't like the performance, which may cause incidents of ownership. Okay, the next question is simply, can you do a 1035 exchange for the policy if it's already in the ILIT?
I'll speak for myself. I've not done 1035 exchanges with policies held in an ILIT. I'm not saying that it couldn't be done. I haven't researched it or looked into it. I've always tried my best with clients to say that once you put a policy into an ILIT, you really need to think about that as an irrevocable transfer and not to try to substitute that policy or other assets inside the policy. If I'm going to do something where we're substituting assets, I typically do that with things that are not ILITs. Certainly we can do that with irrevocable trusts. I just shy away from doing that with respect to insurance. Lloyd, have you done any 1035s?
I would agree with you.
Okay.
Yeah.
Okay, thank you. Okay, this one's a scenario. It's for a larger ILIT with settlers' 2 children as beneficiaries. Can one increase the annual exclusion by utilizing the grandchildren of the 2 beneficiaries?
That gets into nicely that kind of Cristofani case that we described in particular, because you might say that the beneficiaries of the ILIT are the children and their issue by representation or something like that. So if a child preceded the insured in death, that maybe the share would then go to the benefit of the next generation. People have had different levels of comfort on that with respect to utilizing those individuals. I have done it personally, but I've advised my clients that, there might be some risk in that. There might be a Cristofani issue. I usually explain what a Cristofani issue is, but for this audience, I'll just call it a Cristofani issue. And so to, proceed carefully. But again, often we're working with larger premiums, and we need those people. And I think that you can make at least a good faith argument that they have a legitimate interest in the policy being successful, either for their parents or if their parents precede the insured in death for themselves. So I have some comfort with that, but I always explain the risk to clients. Lloyd, I assume you've done the same?
Yeah, I would agree.
Okay.
Easy for me to agree with you, Chris.
In this instance, at least.
Yeah.
All right, last question. Will not most ILITs be grantor trusts for federal income tax purposes?
I had anticipated that question when I referred to grantor trusts earlier. Most practitioners seem to draft their irrevocable life insurance trusts, at least in my experience, as grantor trusts. I have from time to time drafted them as non-grantor trusts, had them get separate EINs and things of that nature. Now, there had been some concern a couple of years back where Congress, and again, this isn't meant to be a political statement, but Representative Ocasio-Cortez and Senator Bernie Sanders had a bill that, or had discussed some legislation that would get rid of grantor trusts. And some of us were a little bit concerned about how that might end up shaking out. So for some clients and some practitioners, they did choose to do some non-grantor trust ILITs for that limited purpose. But in general, most drafters and most practitioners do these trusts as grantor trusts. So I'd agree with the questioner on that, John, at least in most instances, Lloyd.
And of course, if you have a non-grantor trust, you want to have a separate ID number at the outset. So,
And it might be a separate ID number for which you're not filing a tax return because there's no income, at least at the outset as well.
Perfect. Well, that concludes our questions. We all appreciate you sharing your expertise with us and great information. As a reminder, if anyone wants to pursue CE credit for this, you need to answer question 5 in our post-webinar survey to receive your certificate. Once again, thank you and have a great afternoon, everyone.
Thank you.
thank you.
Thank you.